Thank you, and thank everybody for giving me your noon hour today to talk to you about wrongful death cases. As Christy mentioned, my name is Tim Semelroth. I'm a lawyer from Cedar Rapids, and I've been doing wrongful death cases for over 20 years. And what I'm going to be sharing with you today are some lessons that I learned because I had good mentors. Some lessons I learned because I learned it the hard way in various cases. And so before we jump right into the substance, in addition to being a personal injury lawyer from Cedar Rapids, I am also a child of the 70s and the 80s, and because of that, I was raised in part by video games, particularly the Atari video games were something that were really popular when I was growing up. And one game in particular that I enjoyed was Pitfall. And for those of you not familiar with Pitfall, Pitfall was a game where you were an Indiana Jones type of adventurer, and you were trying to gather treasure, but you had to deal with all of these obstacles. And so, as you can see on the screen, you had to swing over pits filled with alligators. Yes, that's what alligators looked like in early '80s graphics. You had to there were trapdoors that could take you down to tunnels that had all sorts of other things that you had to watch out for. There were poisonous snakes, there were scorpions, there were just all kinds of things that could kill you. And I was talking to one of my sons, and I was telling him about this game, and he said, "Well, so what's the end? What is the conclusion of the game? What do you get to at the end?" And I explained that back when I was a kid, video games only ended when you died or your parents made you shut off the TV. And so I thought that this would be a good way to focus the comments I'm going to make about wrongful death cases, because obviously they do involve somebody's coming to your office because a loved one has died, and also because there are a lot of things that you need to watch out for that could potentially be harmful to your case and could ultimately lead to a call to your malpractice carrier if you're not wary of them. So I'm going to be talking about them in the context of a typical flow of litigation. So you've got your initial consultation when the prospective client comes in, you interview them, decide whether or not you're going to represent them. The pre-suit investigation that you do, opening an estate, filing a lawsuit, the pretrial litigation, and then the trial itself. And you'll notice that when I talk about these common pitfalls, that they can occur at any one of these stages. So pitfall number one. Pitfall number one is failing to identify everyone who has a claim. And this is important to train yourself to think about all the possible parties who have a claim, because obviously somebody is coming to you, and that person is probably a loved one of the person who was killed. Maybe it's a spouse, maybe it's a child, but there's a lot of nuance in Iowa law to who has the right to pursue a wrongful death claim that you want to be thinking about. So to give you an example of what I'm talking about, let's say you have a husband who is killed because of somebody else's fault, and obviously, if the wife comes to you, you've got she is somebody who under Iowa law clearly has a right to pursue a wrongful death claim. You also have children, and if they're minor children, that's an easy call. They're dependents. The case law is clear, but the law in Iowa is also clear that adult children of a deceased parent may recover for lost services and support. And I've cited those cases in the outline that you have access to. But in the Gale versus Clark case, which is a Supreme Court case from 1987, it makes clear that an adult child is not entitled to damages for loss of parental consortium unless the parent's death has caused a significant disruption or diminution of the parent-child relationship. So if Bart, Lisa, and Maggie were adult children, then you just need to realize a hurdle that you're going to have to overcome in order to pursue a wrongful death case on their behalf is showing that there was a parent-child relationship and it was significant, and so that's something that you just need to prepare the evidence that supports that, because otherwise those claims will be challenged. And then there was a change to the Iowa Code, Iowa Code 613.15a, which recognized, and I believe this occurred about 10, 12 years ago, that the parents of a deceased adult child may recover for associated expense and actual loss of services, companionship, and society. And so you always want to be thinking in terms of, okay, was the person married? Did they have children? Are their parents still alive? Because all of those people potentially have claims. The only other scenario would be if there was a relative of the deceased who is entitled to make a bystander claim, and the Barnhill versus Davis case of 1981 lays out the test for that. It's a fairly rare situation, but if the steps are there. But what I really want to talk about is the idea that in the initial consultation, the practice tip I want to give you about this first pitfall is that it's just very important in a very systematic way to identify all the people who potentially have a claim. And the way that we do that in my office is we have a special intake form specifically for wrongful death cases. And it specifically asks about, of course, a spouse, children, living parents, and the existence of a will. And so those are things that obviously most lawyers know to ask about, but just in case you have a very emotional person who's coming in and you get swept up in the discussion about liability and causation and damages, it's always just important to remember that you're identifying everybody who potentially has a claim. Pitfall number 2, failing to identify everyone who is legally eligible to bring a claim. And you may say to yourself, hey, Tim, we already just went through that. We talked about the people who are recognized under Iowa law as making a claim, but just because people have claims doesn't mean that they are eligible to pursue a claim. And specifically, I would refer you to the case of Madison versus Colby. It's a 1984 case where the Iowa Supreme Court explains who has the right to pursue each type of claim. And so to be even more specific, it talks about how claims like medical expenses, lost earnings, loss of function of the mind or body, pain and suffering that are incurred pre-death, the appropriate party to pursue those claims is the administrator of the deceased estate. On the other hand, if you're talking about pre-death, present value of the loss of a spouse's support, then that would be the deprived spouse. Or if you're talking about the loss of the present value of a child support pre-death, that would be the deprived parent. And so it's important when you're going ahead and drafting your petition, and just as importantly, when you're figuring out who needs to hire you, that you identify, okay, what are the claims being made? When were these losses suffered? In other words, were they pre-death losses or were they losses that have occurred because of the death? And then make sure that you are getting hired by the entity who is legally eligible under Iowa law to pursue those cases. So whether it's the administrator of the estate, or it's the deprived spouse, or the deprived parent. Now, one thing that potentially can come up is sometimes you have a parent who has died. They have adult children, and maybe the adult children don't get along. In that situation, it's important to look at the Nelson case, which is included in your materials. It's a 1985 case, and basically it stands for the proposition that an adult child's claim for parental consortium must normally be brought by the estate, but there are some exceptions to the general rule that are explained in that case. And so if you have a situation where the children, the adult children, are not playing well with each other, then you need to look and see if there's an opportunity for one of the adult children to pursue a case for loss of consortium on their own. So what does that mean? Well, you identify the people who have the claims. You take a look at the table from Madison versus Colby, and actually, if you look at that case, they actually put the proper parties in a table format, which is kind of unique for Supreme Court decisions at that time, and I think they realized how confusing or complicating it can be. And then once you do that, you want to make sure that A, you're getting hired by the people who have the right to pursue these claims, and B, you want to make sure that you're drafting the petition in such a way that it's going to be consistent with what Madison versus Colby says in terms of proper parties. And the reminder, the practice tip I would give is to remember that the estate's claims should be joined with those of any consortium claimants unless good cause is shown. So that takes us to pitfall number 3, which is failing to properly investigate pre-death pain and suffering. And this is one of those things that, of course, that I learned the hard way. And the reason why is because when somebody is killed in a traumatic fashion, it is very common for people to assure the loved ones who are left behind that that person didn't suffer. That sometimes it's said by the paramedic, sometimes it's said by a nurse, sometimes it's said by a doctor, sometimes it's just said by a passerby. And people say that because they think that they are providing solace to the family. What's important, though, from your perspective, is that pre-death pain and suffering is an additional item of damage. And so if there is evidence that the patient, or that the deceased was injured and lived for a time before they ultimately died because of their injuries, it is important to find out whether or not there was pre-death pain and suffering. And so the burden is on the plaintiff. The deceased estate must prove by substantial evidence that the deceased was sufficiently conscious in extent and in time that reasonable minds could differ as to whether or not he or she suffered pain. That's the State of Long versus Broadlawn's case from 2002. And so what that means is that you need to do some investigation. You need to, at the pre-suit stage, if there were people who came to the scene or were at the hospital and they have, any testimony that they can share about potentially the deceased, squeezing people's hands or making any sort of indication that they could hear people or that they understood what was going on, that is important evidence. That can be valuable evidence. Talking to the nurses or any other medical personnel who provided care to somebody after the act which ultimately led to their death. Those are people that you want to talk to because that potentially can increase the value of your claim if you have substantial evidence of pre-death pain and suffering. And so that's one of those things that, if all you do is you just ask the widow, and the widow has heard from, maybe the police officer that, your husband didn't suffer, and you just take that at face value, you could potentially be missing an important item of damage. So that takes us to pitfall number 4, which is failing to have your probate ducks in a row. And this cartoon is, if I had to pick one image that you remember from this presentation, one image that you do not forget, it is this idea of the person who's obviously put the cart before the horse. The reason why that's so important is because Iowa law is clear. An estate for the deceased must be officially opened before a wrongful death suit can be filed. In fact, the Supreme Court has made clear, back in 1995, it made clear that a wrongful death lawsuit is subject to dismissal when the estate was not opened at the time of the commencement of the lawsuit. That's the estate of Dyer case, which is from 1995. And so failing to have the estate open before you file the wrongful death case is almost a guaranteed call to your malpractice carrier. The case is there's going to be a move to dismiss the case. It's likely going to be done after the statute of limitations has passed, and then you're going to be stuck talking to a family that's already been through a huge loss about why their lawsuit cannot go forward. And so that's the biggest component of having your probate ducks in a row. But I would suggest that you also need to take a good hard look at whether or not your firm is capable of handling the estate administration. And the reason why that's important is because if not, you should be having a discussion with your client early on about how fees for the attorney who is handling the estate will be handled. And the reason why that's important is because most people who are pursuing wrongful death cases, most lawyers who are taking wrongful death cases are traditionally taking those on some sort of contingent fee. A lot of contingent fee contracts are pretty broadly worded in the way that they describe that, in exchange for legal services, the client must pay 1/3 of the recovery, and your contract, your standard contract, could be broad enough that you are agreeing that all attorney's fees are being covered out of that 1/3 fee. And if you are not in a position to handle the estate administration, then that means that you are going to be paying that attorney who's going to do the estate work out of your share. And so that's a discussion that you want to be having with the client, and it's a reason why potentially your standard personal injury contract may not be the contract that you want to use in a wrongful death case. So, the practice tips to avoid this pitfall are pretty clear. If your firm is in charge of opening up the estate, do not delay. Always calendar the deadline for opening the estate well before the statute of limitations is going to expire for the wrongful death claim. Always make sure that there is a meeting of the minds between you and the person who's hiring you as to how those estate fees are going to be covered. Is it something that's covered in the context of your contingent fee, or is that something that they recognize is going to have to be an additional payment to a lawyer to do those estate administration duties? So that leads us to pitfall number 5, which is failing to recruit an appropriate administrator. So obviously, if you have the opportunity to recruit an administrator, that typically means that the deceased died without a will. Otherwise, if there's a will, they've named somebody who's going to be the administrator for the estate. But if the deceased did not have a will, then that means that you have the opportunity to select who is going to be named as the administrator. And the reason why is because the administrator does not have to be a beneficiary or even a family member. And it is a mistake to just assume, well, the person who brought the case into my office is going to have to be the administrator in the case. You have to keep in mind that the administrator has multiple roles over the life of wrongful death litigation, including they're the ones signing the documents on the behalf of the estate. They are receiving correspondence on behalf of the estate. They have to be organized. There's certain paperwork that they're going to have to be filling out. And then, most importantly, if the case goes to trial, they are the ones who are the face of the estate during the litigation. And so you have to ask yourself, is the administrator somebody that you want as the face of the estate? And it's important because the jury, either consciously or subconsciously, is going to be swayed by how honest, dependable, reliable it appears that the administrator is. In general, juries do not award money to people who they do not like or trust. And so it's important to select somebody as the administrator, if you have that choice, somebody who's going to be responsible for the tasks that you need the administrator to do, but also presentable during a trial. And so if you have one of those situations where maybe the people who brought you the case, the beneficiaries do not fit that bill, then you need to think about, okay, what other options are available to you? And remember what I said, the administrator does not have to be the beneficiary or even a family member. And so one option that you have is to go ahead and hire somebody from the hometown bank. Have somebody from the trust department that you can hire to be the administrator for the estate. And obviously, this would be important, particularly in bigger cases, cases where there's going to be significant recovery, and there's going to be something that needs to be managed by the estate. It's in cases where you know that there's a good chance that you're going to go to trial, and somebody's going to have to be sitting next to you, representing the estate, and having a clean-cut person from the local bank who probably the bank has put effort into marketing to make people understand how dependable and trustworthy they are. That can be a valuable person to have next to you from a strategy standpoint. So the practice tip is, if you do not have an appropriate family member available to be the administrator of the estate, you should consider recruiting somebody, maybe a trust officer from a bank, another attorney, to serve as the administrator role during the litigation. Number 6, failing to clarify your role to the estate's beneficiaries. Now, the reason why that's so important is because most of the money that is given to compensate for wrongful death is ultimately distributed through the estate of the deceased. Now, that doesn't apply to all money. Any money that's been designated to compensate for consortium, can be ultimately paid directly to that person. but the situation is usually a deceased does not just leave one person behind. You know, they maybe it's a spouse, maybe it's children, and they may have different views about what the value of the case is, whether or not the case should be settled, what a fair distribution is. And so the thing that you need to be aware of is that once the money is on the table, that significantly increases the chance that there's going to be a fight. And so before money is on the table, it is important to explain what your role is and explain whose interests you represent and whose you don't. So what I'm talking about is I always make sure that I explain that my primary duty is to the estate rather than to a single beneficiary. And that if they hire my law firm is, once the estate has been opened, the estate is actually the client of my law firm. And I explain to them that if there are disputes about how the estate's assets should be distributed, that I can't play a role in that, that I can't take any sides in a beneficiary dispute. And in fact, if there is a disagreement about disbursement, they may need to seek independent counsel to resolve it. And the reason why it's important to have this discussion is because you don't want a situation where you do a whole bunch of work on this case and then get conflicted out because people can't decide how it's going to be distributed. And so what the practice tip that I recommend is that if you are representing the estate and the individuals, like for example, the spouse or the children, it's important to discuss the potential conflicts of interest that may arise and get signed consents for the arrangement from all the parties. And so that's something that obviously you want to do back at the initial consultation stage, having that discussion, getting the consent to allow you to represent them. And in most situations, if the discussion is had in the abstract before a specific amount of money is on the table, people tend to be pretty reasonable in my experience. If adult children are like, well, the main thing is we just want to make sure mom's taken care of, and so she should get the lion's share of this, and then the kids we'll just we'll agree to an equal distribution or something like that. Anything that you can do to to let them know that coming to an agreement about things like that. And obviously you can't take one side or another. You can't take mom's side, against the kids or things like that. If you're, but what you can do to get them to talk about it before they're actually counting the dollars is going to save you a lot of headache and heartache in the long run. Pitfall number 7. And this is failing to fast track a wrongful death case. And what I mean by that is, I think most attorneys know that the statute for most wrongful death cases in Iowa is 2 years from the date of the death. And that's it's laid out in Iowa Code section 614.1, subsection 2 and subsection 9. It's usually a mistake to allow a wrongful death case to languish pre-suit if you want to get it on file as soon as you're ready to, or it's rarely a good thing to have it result in drawn out litigation. And so this picture sort of explains why. One of the things that we do in any wrongful death case is we always ask for the last family picture if the deceased had a family, that the last family picture that was taken with all the immediate family right there. And the reason why we do is because a really powerful visual to use at trial or in mediation is just this simple graphic. In this case, if Dad is the one who is the subject of is the one who died, then just blacking out, just putting a silhouette where Dad used to be is such a powerful way to convey the idea of the whole that this family has, and it's a powerful way to convey the loss. And so that's what what you're trying to do in these cases is to convey the magnitude of the loss. Here's what happens if you allow a wrongful death case to drag on either pre-suit or in litigation. It makes proving your client's losses more challenging over time. And let me give you an example of what I'm talking about. So maybe at the time of death, the daughters in this family were cute and have very vivid memories of their father reading to them or playing catch with them in the backyard. But if this case drags on for a long period of time, those really cute kids can turn into sullen teenagers who maybe they don't want to talk about what life was like with Dad, or they don't really remember what life was like with Dad. And those are the people who you're relying upon to testify about what they lost. And if they aren't as they can become less compelling as witnesses over time. The other situation that can occur that makes it more challenging to get the sort of damages that you're entitled to is, let's say that the remaining spouse remarries. That can impact what trial testimony they can offer about their former spouse's services and support. And then the other scenario that I talk about a little bit in the outline is that if the trial occurs well after the deceased's natural life expectancy, the jury, and that can often occur in cases involving elderly, there's always the potential that the jury might award less in damages, considering that by this time the deceased would already be gone of natural life natural causes, even if the bad thing hadn't happened. The other reason why it's important to fast track is that under the new, they're not new anymore, they're over 10 years old, but the Iowa court rules having to do with estates, specifically Rule 23.3b of the Iowa court rules, it was amended back in I think 2008 to say that estates must be closed within 36 months from the date they are open, except for good cause shown. And so what that means is that maybe you got the estate open, or maybe it was open before they ever hired you, but if you aren't doing something proactive to keep the estate open, you can run into issues with that 36-month deadline. And so sometimes an estate will actually be closed before they get to you. Maybe they just wanted to get the house and the property that the deceased left behind distributed, and then they wanted to close the estate, and then they decide, we want to file a lawsuit. In that situation, you're going to have to take steps to reopen the estate, get the administrator reappointed, so that you have the right party to pursue the case. And so the practice tips are wrongful death cases should be worked up as quickly as possible for either pre-suit settlement negotiations or speedy trial. you need to keep track of when the estate was open. And if you're getting close to the 36-month deadline of when the estate was opened, it makes sense to file a motion with the probate court to keep the estate open for the purposes of the wrongful death claim. And so, that obviously those tips apply to the pre-suit stage, opening the estate, filing the lawsuit, pre-trial litigation. All of those steps you want to be moving as fast as possible. So if this is the speed that you normally proceed in maybe a personal injury case, that's you got to realize that you want this to be a bullet train. You want to be moving this forward as quickly and as efficiently as you can. So that leads us to pitfall number 8, which is failing to get court approval for your fee contract and, for that matter, for your settlement. And the reason why is because if you represent the estate in a wrongful death case, it's not enough just to have the beneficiaries or even the administrator sign your fee contract. When an attorney is hired by an estate to prosecute a wrongful death action, whether by contingent fee, hourly, or a combination of the two, according to Iowa Code 633.199, court approval must be obtained showing that the fees are just and reasonable. And then Iowa case law is also clear, and I cited the Sweet case from 1991, that a wrongful death claim can be settled when there are no debts and all beneficiaries agree to a division of the estate. However, the estate may not settle the claim without approval of the probate court. And obviously that makes sense, right? The administrator needs the court to approve important actions like this, like the decision to settle, the decision to hire a lawyer. When you go before the judge, the judge is asking if this is in the best interests of the estate and its beneficiaries. And so obviously a judge is going to take a look at things like, is this an appropriate fee contract, or is this an appropriate settlement? And why this is important to do, and the recommendation I have, the practice tip, is to seek approval of your fee contract at the same time that you're seeking leave of court to bring the wrongful death action. Do not wait until the lawsuit is settled and the money is on the table. And the reason why is because the bigger the number of the attorney fee, the more likely it is that the judge is going to start, monkeying around and saying, hey, is this reasonable? Is this fair? And so, getting court approval as to the fee contract before you're ever talking about dollars and cents, before you're ever getting authorization for the court to settle the case on behalf of the estate, is just a smart move that's going to save you time and effort. And why that's really important is because, when it comes to probate rules, those can sometimes be different based upon the judge, based upon the district that you're in. I know, and I'm not sure if this is still up to date, but the last time I filed, or I tried to get approval for a wrongful death settlement in the 8th district, there was actually a local rule at that time that said that there was a limit to the contingent amount that an attorney could charge an estate absent a good faith showing to the court. And so that's why, you want to be aware, if you are the one who is going to be handling the administration of the estate, in addition to prosecuting the actual wrongful death case itself, you need to be aware of any rules that apply to the administration of the estate and the district that you're in, but also you need to be aware of the judges, and asking around and hearing which judges tend to be more critical of attorney's fee awards, which judges are sticklers, or which judges are going to, if a reputable attorney comes up and you've got all the consents that you need from all the beneficiaries, is just going to sign off on settlements or on the hiring of an attorney. So the thing to keep in mind is that when you're opening the estate, it's always a good idea to make your application for approval of the compensation agreement, with your proposed order, and that's a good way to make sure that it's less likely that a judge is going to be critical of the amount of your attorney fee, particularly if you do a really great job and whatever your percentage is of the outcome is a significant amount of money. When a case is settled, don't forget that the estate cannot settle a claim without approval of the probate court, and that involves submitting an application to the probate court for the approval of the settlement and for the distribution of the settlement funds. And then obviously in your application you want to make sure that you're requesting that the estate be authorized to pay the attorney's fees per the contract that was already approved by the court. That leads us to pitfall number 9, which is failing to hire the appropriate expert witnesses. Now, obviously, there are certain expert witnesses that need to be hired because of the circumstances regarding the liability. If it's a medical malpractice case, typically you need medical experts. If it is a trucking case, maybe you need a trucking expert. If it's any sort of auto case and there's an issue regarding liability, maybe you need an accident reconstructionist. I'm not talking about those type of experts. What I'm talking about are the experts that tend to be necessary in pursuing a wrongful death case, and that typically comes on the damage side, because it is a rare wrongful death case that does not require expert testimony in order to prove certain claims of loss. And what I'm talking about is one of the items of damage that the estate can seek is the loss of accumulation to the deceased estate. And obviously that is a calculation. It's often based upon taxes, other documentation of the deceased earning. It needs to be reduced based upon what was being consumed, because what you're talking about is the accumulation, not just lost, future lost wages, but what was, if the deceased was making money at the level that you would expect them to make and they were spending it at the rate that they would typically be spending it, what was going to be left over, what was going to be there in the estate if the deceased had lived to their natural life expectancy. That is a calculation that typically requires somebody with an economic background to do. Then you have, there are a number of items of damage that you can seek in a wrongful death case that are required to be reduced to the present value. And so again, that is another calculation that typically you need a well-qualified expert to do. And the other component, however, so when it comes to loss of accumulation to the estate, most people, I think, recognize, hey, I'm going to need to find somebody who's an economic expert. Where sometimes money is left on the table in these wrongful death cases is not looking into the extent of the services being provided by the deceased. Is the deceased the cook? Are they the Are they the cleaner? Or do they do the lawn care? Are they the handyman, the handy person for the family? You need to talk to the surviving family about the role that this person had, because that is also an item of damage that can be calculated. What is it going to, how much more is the family going to have to spend if they have to pay somebody to do things that the deceased was doing for them on a regular basis? So that's a way to increase your economic losses, is by having that sort of calculation done. That typically requires first giving your economic expert the evidence about the amount of time per week that the deceased was routinely spending performing domestic services like household chores, home repairs, things like that. And then it typically takes an expert of some kind to go ahead and calculate what the replacement cost for those sort of services is, and then reducing any sort of future lost services to present value. So that is if you want to maximize what you can seek in front of the jury, that means hiring the right experts to help you do those sorts of calculations. And then pitfall number 10 has to do with failing to use appropriate life expectancy information. And this is an area where I'm going to show my age again. When I first started practicing law, and in fact, if somebody asked me, to find the mortality tables right now, typically I would go to the Iowa Code, and I would look, in the last volume where the Iowa Code lists the Commissioner's Standard Ordinary mortality tables, in the back of the last volume of the Iowa Code. And the problem is that those numbers or those tables tend to be rarely updated. And to give you an idea what I'm talking about, in 2004, the Iowa Code still had standard mortality tables from 1980. And the reason why, if you go now, even though it's 2019, if you go now, and you look at the date for the standard mortality tables, you will see that they were updated, I think, in 2001. So you're talking about mortality tables that are 18 years old. And the whole reason, the backstory behind why they moved from 80 to 2001 is an unpublished Iowa Court of Appeals case from 2004. The cites in your materials, it's Anderson versus the state of Iowa. And in that case, the Iowa Court of Appeals found that there were more recent predictors of life expectancy contained in publications like the United States Life Tables from the United States Census Bureau. They also referenced IRS life expectancy tables. And so the point I'm trying to make is that when you're trying to calculate future damages, life expectancy can be an important issue. And so rather than just going to the back of the Iowa Code and looking at data that is, right now, it's 18 years old, I recommend that, you go online, look and see what the United States Census Bureau has for its tables, look and see what the IRS has for its tables, and see if those numbers are better for you. And one of the benefits, particularly with the census numbers, is that if you look at the mortality tables in the that are in the Iowa Code, it just says man and woman, and maybe you would get a better number, or a number that was more helpful to your case, if it was broken down by race, or by some other factor that is measured by the Census Bureau. And so the practice tip is always investigate whether or not there are more up-to-date numbers and relevant life expectancy tables from governmental sources, and the what you need in order to be able to argue that these other governmental sources should be valid is the argument is contained in this Anderson versus State of Iowa case from 2004. And look and see, because those numbers might be better. And that's something that you shouldn't just assume that your expert witness is using the right numbers. That's something that if you've hired an economic expert, you want to talk to them and make sure that that they're using the best numbers and the numbers that you can get the judge to agree, and hopefully get the judge to reference those numbers in a jury instruction. So those are the 10 pitfalls that I've discovered over the years in Iowa wrongful death litigation. You will see that in your box on the right that there's a PDF that has the outline that I've been referencing through this presentation, and also on the last page of it, it has a sample of a initial questionnaire that our firm uses for wrongful death cases, and that might be of help to you. But that is the end of the information that I wanted to share to you today, and hopefully if you follow the tips that I offered today and pay attention to the issues that we raised, you won't be in a situation where you get bad news that it's game over because of a mistake that you made. So I'm happy to open it up for questions if somebody wants to type a question into the chat box on the right. Otherwise, if you prefer to ask a question privately, my email address is listed on the screen now, tsemelroth@fightingforfairness.com. I appreciate the chance to present, and hopefully you all found this a good use of your lunch hour.